Welcome back to Furious HOA Karens. I asked for records and they panicked. You are not going to outsmart the policy. That was Vanessa Hayes, Special Assessment Coordinator for the Ridgeview Estates Commons Association, standing 3 feet from my driveway at 7 in the morning, waving a folded attorney invoice like it was a warrant. I work as an airline baggage supervisor, which means I have seen every kind of chaos, every kind of liar, and every kind of meltdown at 30,000 feet or on a tarmac at 2 in the morning. This was all three at once, except it was Worcester, Massachusetts, and the sun was barely up. She took a step closer. The invoice is finalized. Legal costs are not up for debate. You owe $460 by Friday, or we file a lien. She was wearing a gray light jacket with the hood up and a blue baseball cap, and she had a crossbody bag stuffed with paper packets that looked like they had been printed 5 minutes ago. Behind her, a mail carrier was trying to get around the crowd at the mailbox cluster, but 3 neighbors had stopped to watch, and nobody was moving. I kept my phone in my hand, chest high, recording light visible, screen turned away. I said, "I need to see the breakdown." She said, "It is in the portal." I said, "It is not. I checked last night." She said, "Then you are looking in the wrong section. That is not my problem." Her voice went up half an octave and the neighbors started whispering. I said, "Vanessa, if the invoice exists, show me the line items." She opened the red folder she was clutching and pulled out a single page with no header, no date, no attorney name, just a dollar amount circled in red pen. She said, "This is the invoice." I said, "That is a photocopy of a number." She said, "You can be mad, or you can be compliant." That line stuck with me because 6 months earlier, she had said the exact same thing when the HOA tried to tow my car for a parking violation that did not exist. I had been working a double shift, my elderly parent was staying with me recovering from surgery, and I came home at 4 in the morning to find a notice zip-tied to my door handle that said my vehicle was in violation of overnight guest parking limits and would be towed within 24 hours. I called the management company. They said the notice was issued by the board. I called Vanessa. She said, "We can tow first and explain later. That is how enforcement works." I filed a complaint. The tow never happened. The notice disappeared from my account. Nobody ever explained it. I let it go because my parent needed me and I did not have the energy to fight a paper war. Now she was back with an invoice that made no sense, and I realized the tow scare was not random incompetence. It was connected. I said, "Vanessa, I am filing a records request. I want every invoice from the attorney for the last 18 months, every board resolution authorizing legal action, and every tow authorization signed by the board." She said, "You can request whatever you want. Processing takes 30 days and there is a copy fee." I said, "Massachusetts law says reasonable fees." She said, "And we decide what is reasonable. 50 cents per page. Certification is $25 per document. Prepayment required." The mail carrier finally squeezed past us and muttered something about needing a traffic cop. One of the neighbors, an older guy in a Bruins hoodie, said, "Vanessa, is this about the tow thing from last year?" She turned on him fast. That matter was resolved. "This is a separate assessment." He said, "It does not look separate." She said, "Then you do not understand how the association works." She turned back to me. "You have until Friday. The invoice is valid whether you believe it or not." She walked away, clutching the red folder like it was evidence she was not allowed to share, and I stood there with my phone still recording, and a clarity I had not felt in months. I went inside and pulled up every email, every notice, every portal login I had saved. My parent was asleep in the guest room and I did not want to wake them, so I worked at the kitchen table with the lights off and my laptop screen too bright. Ridgeview Estates Commons Association runs like a place where everything requires a form and the form requires another form. Every decision gets documented, every rule gets codified, every complaint gets logged. Except when it does not. I found the TOW notice from 6 months ago in my trash folder. No signature. No board resolution number. No date stamp. Just a paragraph of text and a deadline. I found the invoice Vanessa had waved at me this morning. It was not in the portal. It was not in my email. It was not anywhere except the photocopy she had shoved in my face. I opened a spreadsheet and started building a timeline. The TOW notice appeared on March 3rd. I filed a complaint on March 5th. The complaint was acknowledged on March 7th with a generic auto-reply. On March 9th, I got a call from the management company saying the matter was being reviewed. On March 15th, I got an email saying the board had reviewed my complaint and determined no violation occurred. The notice was removed from my account. No apology, no explanation of why it was issued in the first place. The email was signed by the property manager, not Vanessa, but Vanessa was copied. Now it was September and Vanessa was back with an attorney invoice for $460 tied to a legal matter I had never been notified about. I checked the portal again. Nothing. I checked my email going back 2 years. Nothing. I called the management company and got voicemail. I left a message asking for the invoice breakdown and the board resolution authorizing the legal expense. Then I called the attorney listed on the generic HOA letterhead and asked if they had billed the association for any matter involving my address. The receptionist said she could not discuss client matters. I said, I am the homeowner and I am being billed. She said, then you need to request records from the association. I said, I am trying. She said, good luck, and hung up. I let the frustration sit for about 10 seconds, then I did what I always do when someone is lying to me. I started looking for the pattern. Vanessa had a history of moving goalposts. She had done it with the TOW notice, and now she was doing it with the invoice. If the invoice was fake, there had to be other fake invoices. If the TOW notice was fake, there had to be other fake notices. If she was willing to lie to me, she was willing to lie to other people. I needed to find out who else she had targeted and what they had found. I spent the rest of the morning calling neighbors. The guy in the Bruins hoodie, whose name was Tim, said he got hit with a landscaping fine last year that made no sense. He paid it because it was only $75 and he did not want to fight. Another neighbor, a woman named Rachel who lived 2 streets over, said she got a notice about her fence being 6 inches too tall, but when she measured it, it was exactly the height listed in the guidelines. She filed a complaint and the notice disappeared. A third neighbor, a retired teacher named Diane, said she got billed for a special assessment to repave the guest parking lot. But the guest parking lot was never repaved. She paid it because the notice said failure to pay would result in a lien. Every story had the same shape. A notice that did not make sense. A demand for money. A threat of escalation. A sudden resolution when someone pushed back, but no explanation and no apology. And every story involved Vanessa. She was the one who issued the notices. She was the one who handled the complaints. She was the one who decided when something was resolved. I asked Tim if he had kept the paperwork. He said no. I asked Rachel. She said she had the original notice, but she threw it out after the complaint was closed. I asked Diane. She said she had a copy of the special assessment letter in a file box in her garage. I said, "Can I see it?" She said, "Come over." Diane lived in a split level with a 2-car garage full of storage bins. She pulled out a file box labeled HOA Nonsense and handed me a manila folder. Inside was a letter on Ridgeview Estates Commons Association letterhead dated 14 months ago. It said the board had approved a special assessment of $200 per unit to fund emergency paving repairs in the guest parking area. It said payment was due within 30 days. It said failure to pay would result in a lien and possible legal action. It was signed by Vanessa Hayes, Special Assessment Coordinator. The letter had no board resolution number. The letter had no meeting date. The letter had no backup documentation. I took a picture of the letter with my phone. I asked Diane if she had ever seen the paving work. She said no. I asked if she had ever asked for proof. She said she called the management company and they told her the board had approved it and the work was scheduled. I asked when the work was supposed to happen. She said they never gave her a date. I asked if she ever followed up. She said she did, twice, and both times the management company said the project was still in progress. Then she stopped asking because it felt like they were just running her in circles. I said, "Did you pay the assessment?" She said yes. I said, "Did anyone else?" She said, "I think so." Most people just pay and move on. I said, "That is what she is counting on." I went home and added the special assessment to my timeline. 14 months ago, Vanessa issued a $200 charge for paving work that never happened. 6 months ago, she tried to tow my car for a violation that did not exist. This morning, she waived an attorney invoice that was not in the system. Every time, the threat was immediate, the documentation was missing, and the resolution involved me either paying or backing down. But this time, I was not backing down. I had a shift starting in 4 hours and my car was the only way I could get to work. If she tried to tow it again, I would get fired. That was not a hypothetical theoretical. That was a fact. I needed to move fast. I filed a formal records request through the portal. I asked for every attorney invoice for the last 18 months, every board resolution authorizing legal fees, every tow authorization, every special assessment notice, and every complaint filed against my address. I attached the photo of Diane's special assessment letter and asked for proof that the paving work had been completed. I copied the property manager, the board president, and Vanessa. I hit send and waited. 3 hours later, I got a response. Not from the property manager, not from the board president, from Vanessa. The email said my records request had been received and was being reviewed for compliance with association policy. It said the request involved multiple categories of records and would require extensive staff time to compile. It said the estimated cost was $375, due in advance, and the estimated processing time was 30 days. It said if I did not prepay within 5 business days, the request would be considered abandoned. That was escalation step 1. She was blocking my access to the records by pricing me out and delaying until the invoice deadline passed. I replied immediately. I said Massachusetts law requires HOAs to provide records at reasonable cost and within 10 business days. I said $375 for electronic records was not reasonable. I said if the association did not comply, I would file a complaint with the Attorney General and copy the management company's corporate office. I hit send and went to work. My shift was 6 hours of organized chaos. We had 3 delayed inbound flights, 2 gate changes, and a family that lost a stroller somewhere between Charlotte and Worcester. I spent most of the night on the radio coordinating with ramp crews and customer service, and by the time I got home at 2 in the morning, I had 4 new emails. The first was from the property manager, saying my records request was being forwarded to the board for review. The second was from the board president, saying the board would discuss my request at the next meeting in 3 weeks. The third was from Vanessa, saying my complaint about the records fee was without merit and the fee stood. The fourth was from the management company's corporate compliance office, saying they had received my escalation and were reviewing the matter. I forwarded all 4 emails to my personal archive, and then I did something I should have done 6 months ago. I called the tow company. The number was on the original notice from March. I got a dispatcher who sounded like he was 70 and had been answering phones since before I was born. I said, "I am calling about a tow authorization for Ridgeview Estates Commons Association." He said, "What address?" I gave him mine. He said, "Hold on. I heard keys clicking." He said, "We got a call in March, but we never hooked it. Somebody canceled it before we got there." I said, "Who called it in?" He said, "Let me check." More keys clicking. He said, "Hayes." Vanessa Hayes. She said the vehicle was parked in a guest spot overnight without a permit. I said, "Did she provide documentation?" He said no. She said she was calling on behalf of the board and the vehicle needed to be removed immediately. I said, "Did she say why?" He said, "She did not. She just said it was an enforcement issue and we needed to move fast." I said, "Do you still have the call recording?" He said, "We keep them for a year. I can pull it if you need it." That was the moment I knew I had her. Vanessa had called the tow company directly, without board authorization, without a violation on file, and without any documentation. She had lied to the dispatcher. She had lied to me. And she had done it because she thought I would not fight back. I said, "I need that recording." He said, "I can email it to you, but I need a request in writing." I said, "I will send it tonight." He said, "No problem." Then he said something I did not expect. He said, "Between you and me, she calls us a lot." We have had 3 other calls from her this year for the same complex. 2 of them we canceled before we got there. 1 of them we hooked, and then she called back 10 minutes later and said it was a mistake. We do not like doing business with her. She does not follow procedure and she gets hostile when we ask questions. I said, "Do you have records of those calls?" He said, "Yeah." I said, "Can I get those too?" He said, "If you request them in writing and the owners give permission, sure. I will talk to my boss." I hung up and stared at my phone for a full minute. Vanessa was not just targeting me. She was running a pattern. Fake violations, fake invoices, fake authority. And the tow company was her enforcement arm, except they were starting to catch on. I drafted an email to the dispatcher with a formal request for the call recordings, the authorization logs, and any notes tied to Ridgeview Estates Commons Association. I sent it at 2:30 in the morning and then I went to bed knowing I was not going to sleep. The next morning, I got an email from the tow company owner. He said he had reviewed my request and he was willing to provide the recordings and logs, but he wanted to meet in person first. He said he had concerns about how the association was using his company and he wanted to make sure I was serious about pursuing this. I said I was. He said, "Come by the yard at 10. I said I would be there. The tow yard was off Route 146, a gravel lot surrounded by chain link with a trailer office that looked like it had survived 3 decades of New England winters. The owner's name was Eddie. He was in his 50s, built like a retired linebacker, and he had the kind of handshake that told you he did not waste time. He said, "You are the guy from Ridgeview Estates." I said, "Yeah." He said, "Vanessa Hayes is a problem." I said, "I know." He said, "She has called us 11 times in the last 18 months. 7 of those calls we canceled before we hooked because the vehicle was not in violation or the paperwork did not match. 2 of them we hooked and then she called back and said it was a mistake. 2 of them we refused outright because she could not provide board authorization. She keeps threatening to switch to another company, but we are the only shop in Worcester that will even answer her calls anymore." He handed me a folder. Inside were printouts of the call logs, 3 audio files on a USB drive, and a timeline he had built himself. He said, "I started tracking this because I got tired of her yelling at my dispatchers. Every time we ask for documentation, she says the board does not need to provide it and we just need to do the job. Every time we refuse, she threatens to file a complaint with the state. She does not understand that we are liable if we tow without proper authorization. We are not her personal enforcement squad." I said, "Can I use this?" He said, "Yeah. And if you need me to testify or write a statement, I will do it. She cost me 2 contracts because other HOAs heard she was using us and they thought we were sketchy. I want her on record." I took the folder and the USB drive and I went home and spent the next 6 hours building a case file. I had the special assessment letter from Diane with no proof of work. I had the tow notice from March with no board resolution. I had the attorney invoice from this week with no backup documentation. I had the call recordings from the tow company showing Vanessa calling without authorization. I had the email chain showing her blocking my records request with an illegal fee and an illegal delay. I had a timeline that connected every piece. I had witnesses. I had evidence. I had proof. And I had a trump card I was not going to reveal until the moment it would hurt the most. The board meeting was scheduled for the following Thursday. I submitted a request to speak during the open comment period. The property manager confirmed my request and said I would have 3 minutes. I said I needed 5. She said the board does not allow exceptions. I said, then I will file a formal complaint and request the Attorney General investigate the records denial and the fake invoices. She said, I will ask the board. 2 hours later, she emailed me back and said I could have 5 minutes. I spent the next 5 days refining my presentation. I printed copies of every document. I highlighted the contradictions. I built a packet with a cover page, a timeline, a summary, and tabs for each category of evidence. I made 12 copies. 1 for each board member, 1 for the property manager, 1 for Vanessa, and 1 for me. I practiced my opening 3 times. I timed myself. I cut it down to 4 minutes and 50 seconds. I left 10 seconds for the moment I was going to drop the recording. Thursday came and I got to the clubhouse 20 minutes early. The meeting room was set up with a long table for the board, 2 rows of folding chairs for residents, and a podium with a microphone that looked like it had been installed in 1987. Vanessa was already there, sitting in the front row with her red folder and her crossbody bag. She did not look at me when I walked in. The board president, a guy named Colin who worked in insurance, was setting up his laptop. The property manager, a woman named Jessica, was passing out agendas. I sat in the back row and waited. The meeting started at 7. The board went through the standard agenda, approval of the last meeting's minutes, financial report, landscaping update, violation report. Vanessa gave the special assessment report. She said the association had collected 83% of the paving assessment and the project was moving forward. She did not say when, she did not say where. She did not provide any proof. Colin said, "Thank you, Vanessa." Then he said, "We have 1 open comment request tonight." He looked at me. "You have 5 minutes." I walked to the podium and set down my packet. I said, "My name is on file and I live at the address on file. I am here to discuss a pattern of fraudulent notices, fake invoices, and unauthorized enforcement actions conducted by Vanessa Hayes in her capacity as Special Assessment Coordinator." I handed out the packets. Vanessa's face went red before I finished handing out the 3rd copy. Colin said, "This is a serious accusation." I said, "It is a documented accusation. Turn to tab 1. I walked them through the timeline, the special assessment for paving that never happened, the TOW notice with no board resolution, the attorney invoice with no documentation, the records request blocked with an illegal fee. I said, every single one of these actions was initiated by Vanessa Hayes without board approval, without proper documentation, and without any legal basis. I have proof that she called the tow company directly and misrepresented her authority. I have proof that she blocked a lawful records request in violation of Massachusetts General Law Chapter 183A. I have proof that she collected money for work that was never performed. And I have a recording that proves she knew exactly what she was doing. Vanessa stood up. She said, "This is slander." I said, "It is evidence." She said, "You are making accusations based on incomplete information." I said, "Then provide the complete information. Show me the board resolution for the tow. Show me the attorney invoice breakdown. Show me the proof that the paving work was completed." She said, "I do not have to answer to you." I said, "You are a fiduciary agent of this association, and you absolutely have to answer." Colin said, "Vanessa, sit down. Let him finish." I turned to the board. I said, "I filed a records request 14 days ago. I have not received a single document. Instead, I received a demand for $375 and a 30-day delay. That is not compliance. That is obstruction. And it is illegal. I request that the board immediately provide the records I requested, suspend Vanessa Hayes from any enforcement authority pending an independent audit, and refund every fraudulent charge she has collected over the last 18 months. If you are enjoying this story, please like and subscribe for more HOA revenge where the paper trail wins. Vanessa said, "This is ridiculous. You are trying to weaponize a procedural complaint because you do not want to pay a legitimate invoice." I said, "Then show me the invoice." She said, "It is in the system." I said, "It is not. I checked." She said, "Then you do not have access." I said, "I have full portal access and there is no invoice." Colin said, "Vanessa, is there an invoice?" She said, "Yes." Colin said, "Can you pull it up?" She opened her laptop. She clicked for about 30 seconds. She said, "It is not showing up right now." Colin said, "Why not?" She said, "The portal has been glitchy." Jessica, the property manager, said, "I have not heard about any portal issues." Vanessa said, "Well, there are issues." Jessica said, "I can check from my end." She opened her laptop. She clicked. She said, "I do not see an invoice for his address." Vanessa's face went from red to pale. She said, "It was uploaded last week." Jessica said, "I do not have a record of it." Colin said, "Vanessa, did you upload an invoice or did you not?" She said, "I provided him a copy." Colin said, "That is not the same thing." She said, "The copy is sufficient." Colin said, "No, it is not. If you are billing a homeowner for legal fees, there needs to be a board resolution, an invoice from the attorney, and a record in the system. Do we have any of that?" Vanessa said, "The board authorized legal action in March." Colin said, "For what?" She said, "For the parking violation." Colin said, "What parking violation?" He looked at me. I said, "The one that did not exist. The one she invented. The one that disappeared the moment I filed a complaint." Colin said, "Vanessa, did you issue a TOW notice without board approval?" She said, "I issued it under my enforcement authority." Colin said, "You do not have enforcement authority for parking violations. That is management's job." She said, "The board delegated it to me." Colin said, "No, we did not." I let the silence stretch for about 5 seconds. Then I said, "I have one more piece of evidence." I pulled out my phone. I said, "This is a call recording from the tow company. It is from March 3rd, the day Vanessa called them to tow my car." In the recording, she identifies herself as calling on behalf of the board. She provides no documentation. She provides no violation number. She tells the dispatcher to move fast because it is an enforcement emergency. The dispatcher asks for board authorization. She says she does not need it. The dispatcher cancels the call. I request that the recording be entered into the meeting minutes. I pressed play. The recording was 47 seconds. Vanessa's voice was clear. The dispatcher's confusion was clear. The lack of authorization was clear. When it finished, Colin said, "Vanessa, is that you?" She said, "That call was taken out of context." I said, "What context makes it okay to call a tow company without board approval and lie about your authority?" She said, "I was acting in the best interest of the association." I said, "No, you were acting in your own interest. You have been running a scam. Fake violations, fake fees, fake invoices. You collect money, you block records requests, you threaten people who push back, and you rely on the fact that most people will just pay and move on. But I did not move on. And now you have to explain yourself in front of the entire board." Colin said, "This meeting is going to recess for 10 minutes while the board discusses this in executive session." I said, "I request that the board vote tonight on whether to suspend Vanessa's authority and approve an independent audit." Colin said, We will discuss it. Vanessa said, "You cannot suspend me based on his lies." Colin said, "They are not lies if he has recordings and documents." Vanessa said, "He is twisting everything." Colin said, "Then you will have a chance to respond. Right now we are recessing." The board filed out. Vanessa stayed in her seat, clutching her red folder. I stayed at the podium. Jessica came over and said, "I had no idea this was happening." I said, "I believe you." She said, "If even half of this is true, we have a massive liability problem." I said, "It is all true. And it is bigger than just me." She said, "I am going to pull every transaction Vanessa has handled in the last 2 years." I said, "Good. Start with the special assessment." The board came back after 12 minutes. Colin said, "The board has voted to immediately suspend Vanessa Hayes from all enforcement and financial authority pending an independent audit of her transactions. We are also voting tonight to approve your records request at no cost and to refund any fees you were improperly charged. Additionally, we are going to retain an attorney to review whether any of Vanessa's actions constitute fraud or breach of fiduciary duty." Vanessa said, "You cannot do this." Colin said, "We just did." She said, "I will sue the association." Colin said, "You can try." Vanessa grabbed her red folder and her bag and walked out. She slammed the door so hard the podium microphone picked it up. Colin said, "I apologize on behalf of the board. This should not have happened." I said, "I appreciate that. But I need more than an apology. I need the audit to be completed within 30 days. I need a full refund of the fake attorney invoice and any other charges Vanessa collected without authorization. And I need a written policy that prevents this from ever happening again." Colin said, "Agreed. We will put it in writing." I sat down. The meeting continued for another 20 minutes, but I did not hear any of it. I was thinking about the tow company, about Diane and her paving assessment, about Tim and Rachel and everyone else who had paid a fake fee because they did not have the time or the energy to fight. I was thinking about my parent, asleep in my guest room, who had no idea I had just burned down an HOA coordinator's entire operation. I was thinking about Vanessa's face when the recording played. I was thinking about how long she had been doing this and how many people she had hurt and how close I had come to just paying the invoice and moving on. The audit took 4 weeks. The attorney retained by the board found that Vanessa had issued 32 fake notices over 18 months, collected over $11,000 in fraudulent fees, and blocked 6 records requests using illegal delays and fees. She had called the tow company 19 times, resulting in 4 actual tows and 15 cancellations. She had backdated 3 board resolutions to cover enforcement actions she had taken without approval. She had altered meeting minutes twice to remove references to complaints against her. She had created fake invoices from the HOA's attorney by printing generic letterhead and filling in amounts by hand. The attorney had never billed the association for any matter involving enforcement or collections. The board terminated Vanessa's position. They issued refunds to every homeowner who had been improperly charged. They sent a formal apology letter to the tow company and terminated the service contract because Eddie said he did not want to do business with an HOA that had enabled that kind of abuse for 18 months without noticing. They updated the enforcement policy to require board approval for any tow, any fine over $50, and any special assessment. They required the property manager to conduct quarterly audits of all financial transactions. They posted the audit summary in the portal and sent copies to every homeowner. Vanessa tried to fight back. She posted in the neighborhood group chat that the audit was biased and the board had railroaded her because they did not like strong women in leadership. 3 people replied with screenshots of their fake invoices. The group admin deleted her post and replaced it with a link to the audit summary and a note that misinformation would not be tolerated. She threatened to sue the association for defamation. The attorney sent her a letter outlining every fraudulent action she had committed and inviting her to proceed if she wanted the evidence made public in court. She did not proceed. The tow company refunded every improper charge they had collected on Ridgeview Estates calls. Eddie sent me a personal email thanking me for reopening the case and said he was using the audit summary as a training example for his dispatchers on how to spot fake authorization calls. He said he had flagged Vanessa's name in his system, and if she ever called again, he would refuse the job and report it to the board immediately. He canceled the HOA contract the same day the audit was published. I got my records. I got my refund. I got a written apology from the board president. I got a policy change that protected every other homeowner in Ridgeview Estates. And I got the satisfaction of knowing that Vanessa Hayes, who had told me I could be mad or I could be compliant, was now neither a coordinator nor employed by the HOA in any capacity. 3 weeks after the meeting, I was walking to my car for a morning shift when I saw Diane at the mailbox cluster. She said, "I heard what you did. Thank you. I got my $200 back." I said, "You earned it." She said, "No, you fought for it. Most people would have just paid and moved on." I said, "I almost did." She said, "But you did not. That is what matters." I got in my car and drove to work. My parent was doing better. The stress that had been crushing me for months was gone. Ridgeview Estates Commons Association was a place where everything required a form and the form required another form, but now the forms actually meant something. And Vanessa Hayes, who had spent 18 months weaponizing paperwork against people who just wanted to live in peace, was a case study in what happens when someone finally decides to read the fine print and fight back. The cold case was closed. The investigation was over. The evidence had won. Thank you for being here.